Senior Counsel Forde, thanks for joining us. For those of us who've not been following so keenly, tell us which of the elections petition the courts looked at this morning and put it into context for us. What was this morning's hearing about?
Thank you for having me on your show. Today, the Court of Appeal dealt with the appeal in relation to petition number 88. This was a petition filed in the names of petitioners in which we were challenging the validity of Section 22 of the Election Laws Amendment Act and Order 60, which was the order under which the recount was held. In relation to this matter, this was a very important appeal because it is part of the process of ensuring that the PPP ascension to government is subjected to judicial scrutiny. In relation to this appeal, we argued today that Section 22 is unconstitutional, and I will first deal with Section 22 by itself. The argument before the court today was that Section 22 was unconstitutional because of Articles 163 of the Constitution. Articles 163 of the Constitution specifically conferred on Parliament, the National Assembly, the power to pass laws dealing with the manner and conduct in which elections are held. It is our submission that having enacted Section 22, which conferred on GCOM the authority to act when there are difficulties, essentially transferred the power to determine how and when elections are held and the circumstances under which they're held to the Elections Commission in a manner not contemplated by the Constitution. So that was the basis of the argument that we submitted to the court today. Order 60 is connected to that because Order 60 was the basis under which the recount was actually held. It was under Section 22 that GCOM proceeded to put in place and to make Order 60 and then to execute the national recount, which in effect established a system, a scheme under which votes were recounted, recalibrated, reassessed, and presented and formed the basis of the recount and then the declaration of Irfaan Ali as the president of this republic. So it was on that basis that those challenges were made, both in relation to Section 22 and Order 60. We also proceeded to examine, for the court's benefit, for judicial scrutiny and to subject it to a decision to be made by the Court of Appeal. This is having regard to the fact that the Chief Justice ruled against us, ruling that Section 22 was valid and Order 60 was perfectly proper. These are fundamental positions that we disagree with. We articulated before the Court of Appeal this morning something that we believe was of added significance and of great importance and value, having regard to the issues that the court had to raise and be dealt with today. And what I'm speaking about specifically is the issue of what was the impact of the recount held under Order 60, and by extension, obviously, on the basis of Section 22, on the results of the election. We were able to articulate in a very decisive way, Sherrod, the issues concerning this. We were able to point out to the court that it was our view, based on the judgment delivered by the Chief Justice, that there was no reference to the evidence that was presented before the court. We presented before the court evidence in the petition, which was not considered by the Chief Justice, of the fact that the petition attached exhibits, one, showing that in relation to the declarations made, for example, in Region 4, that it was substantially different from the recount tabulation and the recount form used to decide the results of the elections. Those matters were not considered by the Chief Justice. And in the context of the elections as a whole, we believe that the introduction of the recount, the use of the recount, were therefore unlawful. And we tied it in relation to the actual evidence and to what happened, in relation to establishing clearly that there was an unlawful intervention and conduct by GCOM in the management and execution of the elections as a whole, of which the recount was a critical component of it, because it was upon that purported basis that the results were declared. They were not declared on the basis of any statement of polls, even though you hear talks by the PPP of calling for statement of polls and statement of polls. The statement of polls in the context of what happened by GCOM and was done by GCOM, and upon the basis upon which the elections results would have been declared, is of no moment right now. So I believe we have done our part. We have done our job splendidly, thanks to the team and my office, thanks to my support from Mr. Selwyn Peters, thanks to the support of John Jeremy and their chambers and offices, both in Trinidad and Tobago and Canada and other lawyers around the world who would have provided support, information, and discussion. We've been able to present what I believe is a formidable case, which should lead to a decision being made in our favor.
Thanks very much, Senior Counsel, for that response. Senior Counsel Forde, in this morning's hearing, Senior Counsel Astafan made the assertions that some officers at GCOM were actually guilty of misconduct. You responded to that. Here is that statement by Senior Counsel Astafan, and then I want to have your comments at the end of it.
I just want to make one comment, that the difficulties that was being experienced in Guyana and upheld by the respective courts, including the CCJ, were difficulties that prevented the declaration of the results of the election because of the misconduct or conduct of elections officers who were seeking, forgive the pun, to modify the results of the election to suit one side. That is what GCOM was confronted with, Madam Chancellor. Your Honor, I'm sorry. But we don't wish to respond.
Your Honor, in relation to the statement made by my learned friend, learned Senior Counsel Astafan, esteemed counsel as he is, the statement that there was a misconduct or conduct by electoral officers, there is no evidence before this court in relation to that, Your Honor. No affidavit was filed by the Elections Commission, and I believe that that is a most unwarranted statement by counsel at this stage.
I had to respond to Senior Counsel Astafan in relation to that statement. That statement was made by Senior Counsel Astafan in response to my proposition to the court that the issues of difficulties were subject to determination for the court. Mr. Astafan was arguing or attempting to argue in that statement to the court that the difficulties that the GCOM encountered was in relation to staff acting improperly, staff engaging in conduct which could be constituted as misconduct in relation to the conduct of the elections, and that the staff of GCOM were acting in a manner to suppress the will or the results of the elections. I had to respond very sharply to him to point out to the court that there was no decision ever made by any court which indicated that there were ever acts of conduct which constituted misconduct by GCOM that necessitated the action of GCOM to act in the manner in which this did by having a recount. There is simply no evidence filed by GCOM or any other party to this appeal. There was simply no affidavit evidence laid over by the court, and there's absolutely no decision made by the Caribbean Court of Justice, by the Court of Appeal, by any High Court judge, which dealt with any act of misconduct. These persons are charged, they're languishing, awaiting the conclusion of magistrates' court proceedings, which has not been done. We had the farce of a purported commission of inquiry, which I believe up to now, there's no formal report out, but having regard to the evidence that I would have heard, there's nothing indicating, absolutely nothing that could properly be construed and fairly and objectively assessed by those commissioners, which would indicate any act of misconduct on the part of any officer of GCOM. So that is my response in relation to this issue that was raised by Mr. Astafan.
Some of this next question may have been answered earlier, but I wanted to put it into context for Guyanese. Why is this case so important, still very important to Guyanese, or should be important to Guyanese?
I could easily identify at least two reasons. There certainly will be more reasons why this case continues to be of ongoing and continuous importance to Guyanese. First, having regard to the manner in which GCOM conducted itself, this can easily happen again if these provisions are left on the statute books. That is the very first issue. Secondly, we need to exhaust the legal procedures without restriction or limitation on any other lawful measure that can be employed to see the removal of the People's Progressive Party from government. The election petition is an intra-legal process that can possibly lead to the result that we want. And this result is not simply for a legal conclusion that is necessarily barren and just filled with legal arguments, but this is a real issue. This is a real issue. And the Guyanese people must continue to understand and appreciate that the current problems that they face, the current agonies that they endure, the cost of living hardships, the killings, the lack of hope, the failure of the system to work effectively to remove inequalities and inequities, the failure of the system to ensure that the small man could have a fair chance, that people across the country could prosper in this purported Dubai that we're living in. All is essentially tied and inextricably tied to the PPP's presence and occupation of government at this time. So this fight that I am leading and part of is a fight to ensure, not simply a legal fight, not simply an abstract fight to put over a legal argument, but employing the legal system and the legal processes to ensure that we exhaust every effort to free ourselves from the blight and wickedness of the People's Progressive Party. And for those reasons, it remains a very strong possibility that it could happen through this means. I can't swear assertively and say that this is the means, but what I'm sure of, Mark, and what I'm assured by having regard to the will of the Guyanese people and conversations that I would have with them across the length and breadth of this country, and their prayers that they offer and the sacrifices that they continue to make for their families and friends in the face of this wicked and bastardly government, is to ensure that we all do our best to see the backs of the People's Progressive Party.
Senior Counsel Roysdale Forde, I want to thank you for joining us. I know you've had a busy day and the night is still young. Thanks very much for putting this case into context for us and Guyanese at home and abroad. Thank you.
Thank you very much.